Hello friends, in the series on the income tax cases, today we will discuss the case of when OORD ACZ India Private Limited versus Commissioner of Income Tax. This case has been reported in 453 ITR, page number 214. The matter has been decided by Supreme Court and the date of the judgment is 23rd March 2023. In this case, the Assessee was a Indian company and it was a wholly owned subsidiary of a Netherlands company which was incorporated in Netherlands. The Assessee debited its profit and loss account with the amount of mobilization and demobilisation cost which has been reimbursed to the Netherlands company. The question before the assessing officer was that whether TDS is to be deducted on this payment or not under section 195. So, when this matter came to the High Court said that whatever the amount has been paid by the payer to the payee, if the amount is taxable in the hands of the payee, then it is also a determining factor whether the TDS is to be deducted by the payer or not. This was one of the points. And the High Court also held that on the basis of the facts and circumstances of the case, it appears that the TDS is not deductible under section 195 in the present case. But when the High Court passed the order, the High Court made a rider in the order that in future, if the case of the pay is reopened and it is decided that the income of the pay is taxable, then at that point of time, it will be treated that the assessee is in default and there will be disallowance under section 40A clause I. Now, as far as the decision of the High Court for non-deduction of TDS is concerned, that the assessee was not liable to deduct the TDS, the department was in the appeal. And as far as the rider was concerned, the assessee was in the appeal before the Honorable Supreme Court. The Supreme Court said that as far as the decision of the High Court regarding the non-deduction of TDS is concerned, the Supreme Court does not feel that there is any interference required by the Supreme Court. But the Supreme Court also made a rider that the discussion on the question of law on the interpretation of section 195 is kept open. This was a simple rider. The Supreme Court also held that once the High Court has decided that the TDS is not to be deducted in a particular case, then it cannot be said that in future, if the case is reopened of the payee, then whether the income of the payee will be taxable or not at that point of time cannot decide that whether the payer is assessee in default and is liable for disallowance under section 40A clause I. The crux of the question is that if the High Court has decided that the assessee need not to deduct the TDS, then any future event, that is in the present case, if the case of the payee is reopened and it is decided by the assessing officer that the income of the payee is taxable, then that consideration will not make the impact of making the payer of the income as an assessee in default. Friends, the Supreme Court has rightly given the decision in favor of the assessee, because if this type of decision will come with due respect to the High Court, then there will be no certainty to the taxation system, because all the orders will be made subject to some riders. If the High Court has given some decision, then it should have some sanctity and it should not depend in the normal cases on the facts and circumstances of the future events. So friends, in this case, whatever has been held by the High Court as far as the non-deduction of TDS is concerned, that decision come into the favor of the assessee by the High Court also and by the Supreme Court also, and the rider was removed by the Supreme Court that the future event will not determine that whether the payer was assessee in default or not. At the end of this video, once again I am repeating the name of the case. The name of the case is when OORD's ACZ India Private Limited versus Commissioner of Income Tax, and this case has been reported in 453 ITR at page number 214. The matter has been decided by Supreme Court and the date of the judgment is 23rd March 2023. Thank you friends.